60%. And after two, I found
Peace and love, peace and love. It's your brother Isaiah, man, tapping in with another one for all the conscious brothers and sisters in the conscious community. Keeping the struggle, because we know that it's through the struggle that we grow. Also, I would like to say that it is a slow process for progress and that the race is not to the swift, it's to those that remain dutiful. So always make sure you keep yourself in constant study and researching, keeping your brain sharp with the information so you can stay active and updated with. Because the information is not changing like people say, like, oh, it's changing. This information has been around for a long time. It's probably going to be around for a long time. So learn as much as you can. So I want y'all to know that I don't offer legal advice. I'm not a legal counsel. I'm not an attorney. None of those titles. I'm just your brother. I just share with you education and information about my walks and travels throughout my journey called life. I like to extend these honors to you. Because when you honor a man and you honor a woman, you honor yourself. Let me give adoration to the Most High, the head and temple of my life. I like to extend all the honors and adorations to all of his messages and prophets, and peace to all of you, beloved brothers and sisters in grand rising, to all of God's chosen people. Uh, I just want to say first and foremost that you should be taking this stuff very seriously, man. Like somebody's trying to uh deprive you of your right or an interest or ownership or recognition to be recognized as being alive or being involved or participating in any type of transaction, and they're not acknowledging your existence. That's crucial, man. When somebody's stealing your interests, and you are the interest of everything you do. Not understanding that aspect of things is critical, man. So uh you see what's on the screen. If it got the OMB number on it, it's an official document, man. So brother Isaiah, y'all know how I get down, man. I don't do nothing unless it's official. You see what I'm saying? As time go on, I show certain things to you, just to kind of show you. I tell people you need to tap in with. I don't believe me though, so every now and then I show you a little gift. I give you a little something to make you, think, like, man, he just threw that out there just like that. Yeah, just like that. It's more where this come from. yeah, yeah, it's more where this come from. So I just, we each one teach one. We supposed to be helping each other in all actions too. Like I showed you, like I ain't, I'm a good brother, man. And anybody tell you that I I know that part of what I have to do is not always about, it's about teaching and helping each one of us get a better understanding. We should be trying to help each other as much as we possibly can because we all we got, right? And all we need for the evil to keep prospering is for us not to stand together in truth and do righteousness, like, and do good deeds to each other. Like we should be doing good deeds. Like this is a good deed right here because somebody need this. Somebody gonna see this video and be like, oh, thank you. I'm so glad, because a lot of us, we need this information, and some of us is holding information. Really, we should be putting all this information out. You know what I'm saying? Because when you put it out, you keep it. When you hold it, if you die or if they take you away, all that information you had is gone. And you never share, you trying to put it out in portions and this, and that. But that's why you know, more I think about it, like I should be on here more often. I should be teaching more, giving away more information, so that it can be, because it's out here, but most people don't know. Like the information is all around us, but a lot of us don't know how to research. We don't know how to find information. We don't know what to look for, or where even to start. Like they might be thinking, like, well, how did you even find this document? You know, like I gotta get it. You know, people like, what, like, where did you, man? I've been searching forever. I ain't never. It's a method to everything. And once you learn how, once you educate yourself to a certain level of education, you'll be able to find whatever you want because you're educated enough to seek out the things you desire. And education is so important for us, because a lack of it causes us to become indebted, bound to things that we're not even liable for, from a lack of understanding. Now, I'm gonna share something with you. Um, let's talk about let's talk about all right, let's talk about traffic citations. And remember, this is just for educational purposes. It's not legal advice. I don't advise you to take anything that I'm saying and use it first, full-fledged without first investigating, doing your research. And then after you have thoroughly analyzed it and you feel that it resonates with you, then if you feel free to take action, then that's a choice that you make. But make sure you fully understand what you're doing when you do what you do, right? Because just going in there talking it on, a lot of times these people are like anybody sitting in a robe, they know contracts. You best believe it. You best believe it. All right. So let me tell you this. So when a cop writes a ticket, what's actually happening is you're being charged. A charge is like when somebody charge you up. It's like you're holding something if I charge you. And you can dispose of the charge or discharge the charge if you know how, right? Most people don't understand. But anyway, when you're being charged by an officer, he's actually saying that he's witnessing the crime. Okay. You did something. It was a violation of code 67214, right? We know they dealing in codes and statutes, which is not actual law, which is a business. Like it's like anytime you're dealing in codes and statutes, that's civil. Civil is when you're dealing in contracts and civil actions. So all civil actions deal with codes and statutes, right? That's how you know you're in a civil action. Civil actions are non-criminal in nature. The legal definition of civil is dealing pertaining to contracts, agreements, admiralty. When you're dealing in civil, you're dealing in commercial affairs. But admiralty, let's talk about this word that I said, admiralty. Admiralty. Let's see if I can pull this up, show you something. Admiralty.
According to Wikipedia, the Admiralty was a department of the government of the United Kingdom that was responsible for the command of the Royal Navy.
All right, so admiralty, right? It's like it's a special law of the sea. And what admiralty does, like, see, a judge is allowed to construe and construct the law to give meaning of statutes and statutory law his own interpretation. So even though the conduct, like say for instance, you didn't do a criminal act, but because the statutes in the code looks at the style of that action as something criminal in the way that it's being styled, then in the way the judge interprets your actions and the way you interact with the proceeding in reference to your conduct would determine whether or not he would determine whether or not that's actually criminal, because you accept something that's non-criminal as criminal, right? So which shows you have an impairment. So these are the things that they're able to do. You see what I'm saying? They're able to construe and give the law, give that law, statutory law, the meaning that they want. Statutory in nature, meaning government-made law. And like when you're dealing in statutory law, you're dealing with statutory persons. That's why when they charge the statutory person, because they're dealing in statutory law. Now, when you come into court, one thing you must always remember. All right, so I'm gonna explain it to you this time so you can get it, because it's very important that we understand this. And then as your brother, it's my responsibility to provide information that's accurate to you so that you can understand what's actually happening and have a way to remedy a situation. So when a cop writes a ticket, or any charge for that matter, he's acting as a witness. The state is the person that's allegedly claiming injury for breaking a statute or code or whatever the fact it may be, right? Now, when the officer writes the complaint against you, right, he has to authenticate that. Basically, he has to take it before or a prosecutor, and then he has to verify or give certification that the information is true and correct in his statement. Once he gives a sworn statement of fact and say that the statements are true and correct, the prosecutor takes that statement from the officer and then he files the original complaint into the court against you. He files the suit. Okay, so the prosecutor takes the complaint. He first has to get the officer to swear that the complaint is true and correct, which their oath is incorrect. Once you understand the civil rules of how the oath should be styled, and you look at the style of their oath, which I have a copy of the document, and I should upload it so you can see it, so you can understand what I'm talking about and what they do wrong, right? So when he files that original complaint, he files a petition against you. He sues you for what the officer said you did. He looks at the complaint, and the officer saying this is what state law he witnessed you do this, this, and that, and then and he gives a certification on that statement. Then he takes that as the statement to sue you with, which is a violation because that's the witness statement. All right, the cop is not the party saying that he was injured. So if in fact you were to be sued, it would have to be by a person claiming firsthand knowledge. The cop is not the firsthand. He's not claiming that he's injured. So he shouldn't have been able to take his complaint as a witness and that complaint be used to sue you. That's improper right there. So what the prosecutor does is he sues you based off a third party's witness statement. All right. So then when you come into court, right, the only thing you should be doing is challenging the jurisdiction of the court and the prosecuting attorney's claims as void because they're not supported by a sworn affidavit of fact from a damaged party. You know what I'm saying? Unless he can, and if he try to speak in the courtroom, you should always object and demand that anything that he put in the record be removed from the record, because according to Rule 19, only persons with firsthand that has a substantial interest may be joined in as parties in any court proceeding. He's not a firsthand party. So how are you joining in any of these proceedings? How are you making a statement in any proceeding as a party that's not joined in? You're not claiming damage or injury. You're not stating that you are a firsthand party who suffered sufficient damages. If the state is the one injured, the state got to present the claim. You can't present that claim. So when they do that, All that's improper because what he's doing is he's acting as a claimant. Anytime he come to court and he's saying you committed this and you did that, he's acting as if he's the one that you did it to. You see what I'm saying? When he wasn't even there at the scene at the time when it took place. So anything he say is a hearsay unless he can substantiate that, unless you can validate that what you're bringing before the court is an actual claim of injury, like unless you can validate and bring forth the claimant who is making an actual claim of damages, then you know what I'm saying, you challenge everything. You tell them to substantiate that. You know, I need that substantiated. I need you to swear under the penalty of perjury that you have a sworn claim, and I need that any claim against me by a claimant be presented for the record. I need that you present your record for your claim injury, right? So when if he present a record to you and it's not a sworn affidavit from an actual claim party, because if it's Officer David, if it's a statement from an officer, that's invalid because the officer is not uh 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 a claimant of injury. He's not the one claiming that he suffered personal injury. This is a third party witness statement. Do you have an actual statement from an actual firsthand party who has suffered actual injuries as a firsthand claimant? If you don't have that, then I'm demanding that they I'm moving the court to dismiss all charges with prejudice, for the prosecutor has brought a claim before the court in which relief can't be granted because there's no firsthand claimant who has actually suffered that I can actually grant relief to. Because it can't be the cop and it definitely can't be you. And if there's nobody in the courtroom with an actual affidavit saying that I injured them, one of the main rules of the civil rules of procedure is that what is it? That you must give an answer to the complaint. Let me show it to you real quick. We're gonna go to, what is it, rule. Let's see, civil rules of procedure. All right, we're gonna go to civil rules of procedure, right? So when you go to the federal civil rules of procedure, if you're not familiar with your federal rules of procedure, you need to learn this. Like for real, like I can't say it enough, man. You gotta learn this. I mean, a lot of stuff we just can't get. It's just certain stuff, man. You just can't get around it, bro. You gotta know it. It's mandatory. If you trying to, especially if you talking about making claims and get contracts and what you better get this in your skull because you're gonna need it. I guarantee you that you're gonna need this because this is how the court operates, right? This is and this right here in the what is it, the Supreme Court rules, they coincide with each other. They work hand in hand, bro. Like, and with your state statutory laws, what they call the statutory codes and statutes, all that stuff. When you The reason why I know, because I've been reading all this stuff because I want to know the truth, bro. I don't want to be blind. I want to know everything. I want to know their laws. I want to know the laws I'm supposed to be. I want to know everything that I'm supposed to know. Because if I don't know what they're supposed to be doing, then how can I hold them accountable by not knowing what they statutes and codes require? So it doesn't just mean that I'm learning this for me because this don't apply to me. No, it applies to them. And that's why I'm reading it, because I want to know what they're supposed to be doing. Right. So that's why you read it. We got the wrong concepts of a lot of ways that we see stuff, man. And you got to change that concept because you're limiting your growth and you're limiting your development when you restrict yourself based off saying, I don't have to read that. That ain't applied to me. I want to read constitutional stuff. You want to read everything because you're capable of retaining anything that you desire. So remember that. It's very important that you keep that in mind. Let me get to it, right? So when you go to, all right, the civil rules, it says these rules govern the procedure in all civil actions. See that word right there, civil actions? I'm gonna show you some. And proceedings in the United States District Courts, right? Except as stated in Rule 81, right? They shall be construed. See, when I told you that the judge can construe and give interpretation of what he interpreted to mean, look at that word, construe, administer, and employed by the court. See, and the parties to secure just, speedy, and inexpensive determination of every action and proceeding. Okay, now let's keep going. All right, and if you want to know more about like what this all pertains to, you go down here to the notes of as an advisory committee and you read these notes. These notes are so important. I listen, I didn't even know they was down there. I used to read that and never go to the notes. I started reading the notes. I say, oh boy, these notes are critical. It give you case law, it give you everything, man. Like this is, man, I'm trying to tell you. Once you start diving in and start really wanting to know it, man, you're gonna be so fed, you're gonna be so full of life and information. You're gonna be walking around just like chest out because you know the truth and you can stand on the truth that you represent. And that's the thing, it's not to speak truth, but to be able to walk in the truth you speak, to be able to live as that person that you represent yourself to be to the world. You see what I'm saying? And yeah, things like that. Let's keep going though. Let me go back though. And we go to rule 2, right? This is one of the most important rules. I'm finna show you why, right? So when you go to rule 2, it says that there is one form of action. And it says that it's what? The civil action. You see that? So when they say they suing you for criminal, according to federal rule 2, that's only one form of action, sir. Why is this styled as criminal when the civil rule says it's only one form of action and that's a civil action? Now, why is that important? You know why that's important? You want me to show you why? I'm gonna show you why. I'm gonna show you why. I'm gonna jump back to that. Now, let me make sure that it's showing on my screen because I would hate for y'all not to see this. All right. So the reason why this is so important, right? There's only one form of action, right? Only one. It's called the civil action, right? And then when we look up the legal definition of civil action, it says a civil action is a non-criminal. Wait a minute. We're going to stop right there. You mean to tell me all this time these been non-criminal offenses against us? I did 20 years, man, for something criminal. And I'm finding out now today that the action in itself is non-criminal. You see what I mean by incompetent? And why they do plea deals and why they take you in the back room and say, I talked to the prosecutor and everything seems so secretive. When I was in the courtroom, I used to wonder why the hell was they acting like it was like everything was so, when we whispering in the courtroom and like we hiding from the big bad wolf or something, like, what the? Because it's a non-criminal lawsuit. And you about to go in here and testify to a criminal action in a non-criminal lawsuit. You know what that means? Man, we should take them back for everything they ever did to us. Because do you see what I'm showing you right here on the screen? You molesting our people out here, man. under 9 criminal lawsuits and you're styling them as criminal because you get to construe the law to mean what you want. You clever devil. You clever. But you can't box with God. Can't box with God. A non-criminal lawsuit that begins with the complaint and usually involves what? Private parties. Ain't you a private person? One party suing another party in a non-criminal lawsuit, styled as criminal. They all working in cahoots together. This is what you call when you go to Title 15 when they talk about, let me show you. Illegal monopoly in accordance to Title 15.
According to Cornell.edu, every person who shall monopolize, or attempt to monopolize, or combine or conspire with any other person or persons to monopolize any part of the trade or commerce among the several states, or with foreign nations, shall be deemed guilty of a felony, and, on conviction thereof, shall be punished by fine not exceeding $100 million if a corporation, or, if any other person, $1 million, or by imprisonment not exceeding 10 years, or by both said punishments, in the
So
discretion of the court.
if I can prove that you're trying to monopolize me by one doing this, right? What is they doing to try to monopolize on you, right? Legal definition of incrimination.
In law, incrimination refers to the act of making someone seem guilty, especially of a crime. It can also be a special defense where the accused offers to show that another person committed the crime. To incriminate means to charge with or show evidence of involvement in a crime or fault, while incriminating refers to showing or suggesting involvement in a crime.
So the act of making someone seem guilty. So if I'm incriminating you, if I make you feel like you did something wrong, when actually no wrong is involved at all, right? But I want to make you believe that you're doing something wrong. Now I'm showing you according to rule 2 of the Federal Rules of Procedure that all actions are civil actions and that a civil action is non-criminal action in nature between two private parties going through a civil action, right? But you style it and construe it to mean criminal, and you make me believe in my mind that carrying a weapon without it being registered was a criminal act, or having drugs in my possession was a criminal act. Because of the way that the law is construed and styled, even though no crime is being committed. You see what I'm saying? So that right there in itself is an incriminating act when they take you into court and trying to make you feel like you're supposed to plead guilty and stuff till ain't nothing happen, right? In law, it's the making someone seem guilty, especially of a crime. So why would it say incriminating this to make you feel like you committed a crime? It can also be special defense where the accused offers to show that another person committed the crime. You see what I'm saying? It says to incriminate means to charge with or to show evidence of involvement in a crime or fault, while incriminating refers to showing or suggesting involvement in a crime, right? Now check this out. Now I'm gonna tell you why it's a two-edged sword, and you got to learn the law, right? Now check this out. Now let me go back. Go back up. Show you something. Legal definition of charge.
According to Cornell.edu, in criminal cases, a charge is a formal accusation of criminal activity. The prosecuting attorney decides on the charges after reviewing police reports, witness statements, and any other evidence of wrongdoing.
Let that ruminate for a minute. Let that ruminate in your mind for a minute. Now I just showed you what an accusation, right? Or when somebody's trying to incriminate. Somebody's trying to incriminate you, right? And then we turn around, we look up the legal definition of charge, a form of accusation of a criminal activity. Okay, so let's stop right there. We're going to go to accusation. Legal definition of accusation.
Obtaining something through purchase,
No.
gift, or inheritance. Obtaining something through purchase, gift, or inheritance.
No.
In the corporate context, when one firm buys majority interest in another while both retain their identities. The act of becoming the owner of certain property.
All right. So an accusation is a formal criminal charge, right? Against a person alleged. Now you see how how these words keep coming up. Now you got the word alleged popping in. Alleged to have committed an offense punishable by law, which is presented before a court or a master, having jurisdiction to inquire into the alleged crime. So now it's saying alleged. So we go to accusation and it says alleged. Legal definition of alleged. No.
According to the lawdictionary.org, find the legal definition of ledge from Black's Law Dictionary, 2nd edition. In mining law, this term, as used in the mining laws of the United States, Rev.
To state, recite, right? So to allege is to state, recite, assert, or charge the existence of particular facts in a pleading or an indictment to make an allegation. Okay, so it's an allegation. So an allege is to state an allegation. So well, let's finish this GATION, allegation. Let's finish it up. GATION, allegation. Let's look this up because you're playing games with words with us, right? We're going to hunt you down, all right? Because we want to know what you're talking about. What all this stuff is, what is it all about? The tickets, the criminal cases, everything that you're saying, since everything is civil in nature, and it's a civil action according to Rule 2, and an allegation is defined as a claim of facts not yet proven to be true. Now it's starting to make sense to me. Now talk to me, baby, because I'll talk back to you now. In a lawsuit, a party puts forth their allegations in a complaint. Got you now, boy, I got you. I got you now. Indictment, or an affirmative defense. And then uses evidence at trial to attempt to prove their truth. So, wait a minute. Let me put this together. Because I think I got it. I think I finally get it. I think I finally get it. So, a charge is an alleged allegation of facts that is asserted against a man or a woman as a legal person under some type of statutory enactment. It's not yet proven that the person has actually committed the crime because we first have to see the person's state of being. If in fact he's incompetent and not able to maintain his state of being as a man or a woman, then these alleged facts may become a true fact in court. And now a person can actually come to court and present their claims as true, all depending on the state of the person. So if you come into court and they know you coming in as John Henry Doe and you and they're arguing about the facts and they know they can actually sue you. You see what I'm saying? Now these allegations become true because you have accepted, you know, the allegations or what you have been incriminated against. You have been charged as something, and it's an incrimination against you because they're not supposed to be charging you, but they charging you, and you're accepting being charged in some way that's actually false and fictitious, in which they everything that they're doing is an allegation of facts because nobody actually is standing against you with a claim against you. Nobody's standing with a claim. Nobody, even the prosecutor, what he's presenting, he's not able to present his claim. Why? Because his claim is a third party claim, meaning you can't substantiate that you are a first party. Under Rule 19, you can't even put anything into the record unless you are a party of interest. And if you're not a first-hand party of interest, then I demand that everything you present, that he present, be removed from the record, for he's not allowed to enter into the record under Rule 19. You got to be, let's pull up Rule 19. See, because a lot of y'all, you know, you ain't gonna believe it. I'm gonna show it to you. Rule 19. Now, this is a federal rule of procedure, right? Okay. All right. Persons required to be joined if feasible. Required parties, a party who is subject to service of process and whose joinder will not deprive the court of the subject matter jurisdiction must be joined as a party if, in fact, that person's absence, the court cannot accord complete relief among the existing parties. So what this means is, all right, so I'm a party in the case and I'm required to be joined in as a party in order for the court to grant relief. So if I come into court because my principal is on file and I come in to represent the matters being addressed against me in that capacity, right? I come in as the man, right? And I'm addressing matters. If in fact another party that's making a claim against me is not present, right, then they can't accord relief. You know what I'm saying? Because that party is not present in the courtroom. According to Rule 19, all parties who have sufficient, you know, interest in the proceeding must be joined in. So if I demand that the state be joined, and that the party that's actually claiming the damages be joined in, and that the prosecutor as a third party not be allowed to enter statements on the state's behalf, the state must be joined in under Rule 19. You see what I'm saying? Let's start texting me, man. Please. I'm gonna start blocking people if they keep just texting me this crazy. Hey, listen. So under Rule 19, right, it says the person claims an interest relating to the subject of the action and is so situated that disposing of the action in the person's absence may, as a practical matter, impair and impede the person's ability to protect the interest or leave an existing party subject to substantial risk of incurring double, multiple, or otherwise inconsistent obligations because of the interest. If a party has not been joined as required, the court must order that the person be made a party. A person who refuses to join as a plaintiff may be made either a defendant or, in proper cases, an involuntary plaintiff, right? So when you have the rights to be joined in the case, you're supposed to come in as a plaintiff, recognizing that your legal name is stated in the case as a party in the case under that you know what I'm saying? And then you come in as the man to be joined in as the plaintiff for the person. And that's how we supposed to be joined in. But according to law, that, you know, the state have to be joined in as a party to the matter if in fact the state is claiming that it's the injured party. You know what I'm saying? If the state is not present in the room, if only the representatives are present and the state is not able to be present to be, you know, challenged or anything to substantiate its claim, then they don't have a claim to bring forth, period. And once you understand that, you can actually start using stuff like this against them. You know what I'm saying? When you come into there and then they, you know, they're using all these different things, you know, that are actually fraudulent, you know what I'm saying? And they're trying to incriminate you to make you believe that a crime has been committed. And you should always object to the statutory rules and regulations for just because something is legal don't mean that it's lawful. Just because you call it a crime don't mean that it's an actual crime that's actually taking place. If I consent, if I allow you to incriminate me to make me assume that I've actually did something wrong, then I probably come here and want to pay your little fines, your fees. I probably never challenge nothing that the prosecutor is trying to do, reject him being able to speak or do any act, for he's a third party. He has no firsthand knowledge. You know what I'm saying? And just challenging him, telling him substantiate his claims that if he has the right to speak before the court or to do any act before this court, he must do it under oath. Substantiate your claims. I'm challenging your claims as that you don't have an actual valid claim. You don't have the rights to speak. You see what I'm saying? So, and standing, see, you have standing in the court. A lot of people say, oh yeah, you don't have standing. No, you have standing in the court when you come in your proper self as a man. You come in as a man under a special appearance to address matters that have been asserted against your legal person. You know what I'm saying? You letting them know that it's an implied suretyship and that you are actually the representative of the legal person, and that they must recognize the legal relationship between you and the legal person. And you're not accepting any joinder. You're not accepting any joinder. See what I'm saying? Because see, the whole thing is you got to understand that there's two versions. There's a natural you and there's a legal you, which both characters represent you, meaning the flesh is not the real you, nor is the legal person the real you. You know what I'm saying? And when you recognize that, you know, both aspects of your representation and how you gotta, you know, because the principle is the intelligence. And just like I say, like if you're dealing with a court situation and you already got an attorney, all you got to do is start instructing your attorney, giving him instructions. You are the principal. You have the authority to instruct your agent. If he can't perform, then he needs to leave. You know what I'm saying? We got to start being more effective in our positions, knowing what powers we have, what rights we have. Like a lot of us are under contracts or under agreements with attorneys that we are the principal and he's the agent, and we have no formal power of attorney established with that person. We have not issued a document establishing our legal relationship with how we want our agent to act and what rights or what duties that we give to the agent of performance, and then being able to instruct him, being able to issue documents to him for performance, issuing things demanding that he issue or make certain claims or claim certain bonds or whatever it is that you need your agent to do. This is what they're there for. They try to misrepresent. We've been miseducated to believe that they supposed to be, but really, you supposed to be the one skilled at law. He's just your mouthpiece. And if he can't speak in the way that you need him to speak, then he don't need to be trying to, representing you or your property in any proceeding. You see what I'm saying? We always have the rights to operate through third parties. That's the benefit of, you have the rights to do representations. All right, so let me explain this too before I get ready to go. Like when you dealing with yourself as an individual, a lot of people keep creating powers of attorney for themselves. All right, as the taxpayer, as the individual, they don't see separation. For it's almost like a sole proprietorship. And when you understand that, you can't separate yourself from the entity that you are acting as. See, you got to remember you're acting as an entity. You're naturalized, and naturalization is when you became a legal person. Not actually becoming a legal person, but you do have the rights to act as a legal person. That's what your legal right is. Your legal right is you can be a legal person. You can open up bank accounts as a legal person. You can enter into contracts with companies, not real men and women, but their companies as a legal person, which you have legal rights. That's capacity. That's what capacity means. As a legal person, you don't necessarily need a power of attorney. You have what they call what is it called? Authorized representative. So you would do a designation of an authorized representative. You know what I'm saying? Instead of a power of attorney. You know what I'm saying? So you will basically act from an authorized representative standpoint in reference to your legal person, which is more or less to an authorized signer, authorized holder, things like that. So you're acting in a capacity of an authorized representative or fiduciary in reference, or it can be a fiduciary agreement where you're acting in reference as a fiduciary, or some people do what's called suretyship. You know what I'm saying? And they claim under suretyship, the rights to be recognized as a person of power or creditor. So it's all depending on, the way you look at it. But one of the main ways, that I find is that, as a man or a woman, you solely have the rights to represent the legal person, or the legal aspects of your person that you're using, which is the legal person. And that's why you have a title to the person, to the named person that's named in all the agreements, contracts, things like that, because that is your legal capacity. But it's actually a separate, it's actually, it really is a separate entity from you, right? And the reason why it's considered as a separate entity, because it's an organization. And the reason why it's an organization is because it has more than 3 officers. All right. Your legal estate has 3 officers named, usually most of the estates, unless the father name is not on the estate certificate of title, but on most of the certificate of titles, it has the mother, the father, and then it has the child, the creditor's name, the actual owner of the estate, which all 3 parties are stated owners, but the estate is created for the child. So every estate at its original issue usually states 3 officers, which makes it an organization. And that's why it can be have accounts over there, because it's not, and you deal with multiple, a lot of your contracts, you're in contracts with more than one party. Like with T-Mobile is, if you with T-Mobile, they deal with American Banking Association, and usually that's their agent or their stockbroker, where all their stocks that they hold are held with this company. And this company is like an insurance company that insures all the stocks for all the stock investments or the insured holders, which would be the individuals holding the insured accounts. Because everything is insured, every account you acquire is insured under the insurance policy, under the FDIC. All these institutions got to go by GAAP. They got to follow the insurance, the depository insurance policies, everything, whether you know it or not. But I think I covered enough, man. I just wanted to come on and drop a little bit of information, man, just for you to know that when you're dealing with these people, dealing with these courts and things like that, always remember that let me pull it up. Why is an unrebutted affidavit stands as fact?
According to SupremeCourt.gov, an unrebutted affidavit stands as truth. Truth is expressed in an affidavit. Petitioner cannot be forced into 42 U.S.C., which housed the Social Security Act. Child support was not enacted into positive law, so it is not law. C1 U.S.C. 204 prima facie, first evidence.
So, so basically, unrebutted affidavit. So basically everything that they do for like child support, they're doing like affidavits against you. And they're basically swearing that you owe or you something like this. And you're not challenging that presumption. And because that original presumption made against you remains unrebutted, anything you do from that point forward, it's the same thing with like a mortgage. It's the same thing with any agreement that you have. It's the same way. If you want to challenge the mortgage, you got to actually deal with the original mortgage agreement. You want to challenge the lease, you got to deal with the original lease agreement. Everything spires back to the original source where everything started from. So if you have a problem with something, you got to go back to where it started. If it started with credit, then you got to go back to where you first started. You got to see what happened, what went wrong, and if it was something that you did that was wrong, then you can redeem yourself. You see what I'm saying? In reference to what you originally should have done. See what I'm saying? And it shouldn't change the performance of the other party, whether he's collecting or providing, either which way. It shouldn't change his performance. He should still be obligated to perform in the same way that he's performing. Just saying maybe the amount and how it's being displayed might change. So with that said, man, I'm gonna get up out of here. I'll talk to y'all here a little bit later. Like always, I'm gonna leave y'all in love, truth, peace, freedom, justice, and equality for us all. Y'all have a blessed, y'all have a wonderful day. Steady to show yourself approved. Before I go, I want to say too that I do have what is it? I have a Cracking the Code series going on right now. In this Cracking the Code series, I'm going through Article 1 all the way up to Article 9, where we're going through Cracking the Code, where I'll be breaking down all these different articles based off different things that I've learned, understood about these codes. If you want to learn, you're trying to get into these seminars, I think I'm on 3 and 4 now. I did 1 and 2. So what's coming up is 3 and 4, and then I'm gonna continue to go all the way up. I think you should tap in. Trust me, valuable information. You can't go wrong, because with information is the key. You know, once you got the information, you can study it, you can do whatever you need to do with it, anything once you get it. That's all, just get the information. So tap in with me, go to buildingbetterminds.info. And remember, don't cheat yourself, treat yourself to the right knowledge. It's your brother Isaiah signing out like always. Salute to the real ones. Peace and love.